All right, this time court calls cause number 22-11-24571 CBR in the matter of Andres Anchondo, a minor child. If I could have appearances and announcements, please.
Judge Anthony Robles for Ms. Segovia, present and ready.
Your Honor, Trent Graham for Mr. Anchondo, present and ready.
Liza Trevino, Assistant Attorney General, present and ready.
All right, we're here on a motion to clarify from Mr. Robles.
Yes.
All right, you may proceed, Mr. Robles.
Thank you, Judge. Judge, and I'm looking at the court's letter ruling dated March the 31st of this year. It addresses, I'm going to address first the support with regards to the modification. And I don't have my notes in front of me to tell me how much Mr. Anchondo made, but I know that he testified about his income. His income was not minimum wage. His income actually showed that he's making more than what he made at the time of the previous order. And under the code, when the court's going to deviate from the guidelines, the court's got to make specific findings as to why it believes it's best for the child for that to happen. My position is that based on the evidence, this is a deviation from the guidelines, and I would just ask for the court to issue findings on that. That would be the first clarification that I would ask for with regards to the modification. Let's see. Then with regards to, there was another action that the court considered with regards to the enforcement.
Stop.
With regards to the enforcement judge. With regards to the enforcement judge, the issue there is that the undisputed evidence through the pay record that was admitted showed that Mr. Anchondo, there were instances where he didn't pay as ordered. My client's not asking the court right now to make a finding of contempt or issue any punishment for that. However, she is asking that the court order the attorney's fees, that it was not stipulated that they would be awarded the amount that was requested for the enforcement. And correct me, I'd ask the court to ask Mr. Graham to correct me if I'm wrong, but the amount that was stipulated to as reasonable and necessary was $2,500. The court previously awarded my client $2,500 in attorney's fees related to the modification because we were there previously for a final hearing. So the court has awarded my client $2,500 in fees under the modification for the additional fees my client incurred due to the continuance granted to Mr. Anchondo to get the home study done. The attorney's fees under the enforcement judge, the statute makes those mandatory. So I would ask that the court make a finding as to what it believes is reasonable and necessary for the enforcement, and then award those as well. So in sum, Judge, on the modification, I'd ask that the court, one, either order child support according to the guidelines based on the evidence that was presented, or issue findings as to why the court finds it's best for the child to deviate on the enforcement, to find that there were times where Mr. Anchondo did not pay as ordered, make a finding as to what was reasonable and necessary for the enforcement for my client on attorney's fees, and award those under the mandatory portion of the family code related to attorney's fees incurred for untimely paid child support. That's what I got, Judge.
All right, I appreciate that. Mr. Graham?
Just briefly, Your Honor, everything that Mr. Robles is asking for shouldn't be brought through a motion to clarify. What should have occurred procedurally was a motion for new trial on some of these issues that he has. And then our second request for findings of fact and conclusions of law. Neither of that was done. Now, Mr. Robles is trying to use a motion to clarify to get additional rulings and further relief. And procedurally, we've objected to that. We filed our objection. We don't believe that that is the proper vehicle to get what Mr. Robles is requesting. It's our position that your letter ruling wasn't ambiguous. That would be something that you would need a clarification for, and not for seeking additional relief, Your Honor. This has already been litigated. Now he's attempting to litigate this again in a motion to clarify. This case, this order has been pending for quite some time. The court issued its letter ruling. Again, what should have happened was maybe a motion for new trial, a request for conclusions of law. None of that was done. This is an improper way to seek additional relief, and that's what's happening right now, Judge. We think the court's letter ruling was clear, wasn't ambiguous or vague. And again, this motion should be dismissed on its face based on that. Believe that the 2,500 that was held in suspense or in the registry of the court was for the motion or the contempt action. So I think what's happening now is we're seeking attorney's fees in both the motion to modify and in the contempt action. As my understanding, the 2,500 went towards the attorney's fees in the contempt action, not in the motion to modify.
Do either of you recall which hearing the court granted the 2,500?
Yes, sir, Judge, we were there for a final hearing. And then on the eve of the final hearing, Mr. Anchando filed a motion to continue, asking the court to appoint a home study evaluator. We objected to it. And my argument was my client's going to incur more fees to one, deal with the home study evaluation, two, to review it, and three, to prepare for a final hearing with regards with that additional home study evaluation. And it was in that context that the court ordered, I had asked for $5,000 that my client would incur as additional fees to prepare for the final hearing on the modification. The court granted 2,500, and then the court released it after our most recent hearing.
And we paid for the expert, Judge, in its entirety. That final hearing, Judge, was on December 11th. And just one more point, Judge, I'd point the court to Texas Family Code Section 157.421, which governs clarifying orders.
I believe you're correct, Mr. Graham.
Can I share my screen, Judge?
You may.
Thank you. I had to send a request, Judge, to get approval to share.
I'm sorry, give me 1 second. I'm
Yes,
looking
sir.
at the transcript. There you go.
Thank you. The judge over here, findings in the child support order. A3 says that if the court deviates from the guidelines, the court has to make the findings with regards to net resources, what percentage it applied, and the reasons for deviating from the guidelines. So I don't have to file a motion for findings of fact and conclusions at law under 154, 130 of the Family Code, because this deviates from the guidelines. Mr. Anchando makes more than minimum wage just based on the transcript.
Except that you're asking for,
Hold on, just hold on. I understand what you're saying, Mr. Robles, and I agree with you. The thing is that if the court was incorrect in not adjusting the child support, then that's more a question of a new trial. And I do find that the court was incorrect in not adjusting the child support. And I'm granting a new trial on my own motion at this time. Sorry, Mr. Graham, didn't mean to interrupt you, but when I wrote the letter ruling in this matter, I was under the impression that, I guess I had not recently looked at the transcript, was under the impression that Mr. Graham's client was unemployed, but he does testify pretty early on, page 8 of the transcript, that he makes $26 an hour and works 40 hours a week. And then there's some potential for overtime. So the court needs to refigure that amount.
And then on the fees, Judge, I mean, I've got the statute up here, the very first sentence of A.
And I would just add, Judge, it's one thing to quote the statute that requires these things, but you don't do it through a clarifying order. He's asking for additional relief. And I understand the court's ruling on the granting of its own or on its own volition a motion for new trial.
Yeah.
But this is a hearing that occurred back in December.
No, I think that's what's problematic. Like, I understand where everybody's coming from on this. I think what we're here for and how it's been styled as a clarifying motion to clarify, we really can't reach the meat and potatoes, which is, in fact, the court reevaluating its relief that was granted in this matter.
I mean,
But I am
that's-
reevaluating that relief.
and if the court's granting a motion for new trial on its own motion, then I think the court can address all the issues in however it chooses to.
That's what I'm going to do. What I'd like to do, we've got all the evidence and everything in regards to the court's granting of its own motion for a new trial. What I'd really like is for y'all just to send me a 2-page, 3-page summary of what you want and what you think is appropriate, taking into account all of the testimony that we received. If y'all need the transcript, I'm happy to get it to you via Miss Moore, who will charge you for it because we can't cut out the middleman. I got you, Miss Moore. I got you. But I do have it available for myself. So if you want to rely upon your own notes and simply provide that to the court, that'd be fine as well. But I can't take any action today because I don't believe that what we have set this for allows me to grant the relief that Mr. Robles is requesting. But like I said, I have now, having looked at this and having had this hearing, do make that motion on my own for us to revisit it. If y'all can get that to me in like a week, I can get you a new letter ruling in 2 weeks. I really don't want to drag this out any longer. It ended up underneath files mentally and physically, and so we kind of skipped on it for 3 or 4 months, but I'd really like to get this settled in the next 2 weeks. I think you muted yourself, Mr. Robles. I see you talking, but I hear nothing.
It's like I'm having a staff meeting. My staff is always like, "You're on mute, Anthony." And I'll get a request over to your court reporter, Judge, for the transcript. And yes.
All right, so I'll look for that from both of y'all in the next week or so. Okay.
Thank you, Judge.
All right. Thank you, guys.